and go ahead and do that. All right, so your images are going to be captured on this TV camera, all right? Again, you have been wonderful. There have been some exceptions throughout the several years that this case has been on my call, and the exception proves the rule. Everybody here has been outstanding. There's a lot of emotion involved, and I understand that. Both the Laquan McDonald's family and his loved ones, and Jason Van Dyke and his family and his supporters, and the independent people out there. Some call themselves demonstrators, some call themselves protesters, but these are concerned citizens, and they have a but there is the court and effective administration of justice. So let me tell you exactly how I feel. I feel so proud of you. You've been the example for not only for our city and our county and our state, but this is going national on TV. So we will let them see how outstanding individual citizens of this state, of this county, and of this city are, that no matter what the verdict is, and I assume that 100% of everybody's going to be disappointed. So, and that's my job, and I accept it willingly. So thank you. All right. Done. To begin, first of all, we're going to have to go back to when the jury was instructed to get a little insight into this process and into the reasoning for my rulings. Starting off first, the jury was instructed on first-degree murder, and the beginning of the instruction was to sustain either the charge of first-degree murder or the charge of second-degree murder, the state must prove the following propositions. First proposition, that the defendant performed acts which caused the death of Laquan McDonald, and that when the defendant did so, he intended to kill or do great bodily harm. He knew that such acts would cause death to Laquan McDonald, or he knew that such acts created a strong probability of death or great bodily harm to Laquan McDonald. And third proposition, that the defendant was not justified in using the force. Then the next operative paragraph is, you may not consider whether the defendant is guilty of the lesser offense of second-degree murder until and unless you have first determined that the state has proved the above propositions beyond a reasonable doubt. What that means is, first of all, there has to be proof beyond a reasonable doubt that first-degree murder was committed. That is the foundation that second-degree murder consideration has to be laid on. We're not moving any place until the jury came back with the decision that each and every element of first-degree murder has been proven. Then, according to Professor Richard Kling, instead of the common definition of a lesser offense, second-degree murder is first-degree murder, which is the superior charge plus mitigating factors. So the common definition of a lesser offense is that it requires less proof. In this case, the Supreme Court and the state legislature has the right to use what nomenclature they want. They consider second-degree murder a lesser offense. So this is where we have to get before we start analyzing the different propositions. But again, you have to understand that to get to second-degree murder consideration, which the jury did and came back with a verdict of second-degree murder, the condition preceding to even consider the issues are that there has been a finding of first-degree murder, and each and every element of that finding has to be proved beyond a reasonable doubt. Now, moving on. People versus Lee, which is the Illinois Supreme Court, has been quoted quite a bit. And it is a very instructive case concerning second-degree murder and also aggravated battery charged with a firearm. Justice Thomas, in that case of the Supreme Court, framed the issue, which I think is important here, and are all aggravated battery with a firearm cases or crimes more serious than the offense of all second-degree murder cases as a matter of law? He analyzed the different elements of aggravated battery with a firearm, and also the elements of second-degree murder concerning penalties. And if you look, we use a common nomenclature that second-degree murder is a Class 1 felony. Actually, it is a super Class 1 felony. The state legislature decided to increase the penalty on second-degree murder by 33%. Instead of 4 years to 15 years in the state penitentiary with 2 years mandatory supervised release, they increased it to 4 to 20 years in the state penitentiary, along with the other provisions of probation, etc. But looking at that, and then Justice Thomas's analysis of the penalties, his findings were that they overlap because you have the 4 to 20 and you have the 6 to 30. So that would lead to the conclusion, or to support the conclusion, that you have to analyze these cases on a particular case-by-case basis, and the facts in each individual state case controls. And to analyze those facts and to compare which is a more serious offense, and these are case-specific decisions. No general proposition is being issued from this court. This only applies to the case of the murder of Laquan McDonald. So you have to look at the sentences, and once there is this overlapping, we don't have a computer to do that. We have to have a trial judge to look at that to determine which would be the more appropriate sentence for aggravated battery with a firearm or second-degree murder. Back in 1987, our state legislature enacted the crime of second-degree murder. 2 years later, well, it was July, but a little bit more than 2 years later, they enacted the crime of aggravated battery with a firearm. At that time, we have to presume, and certainly our state legislature knew the difference between these two crimes, and certainly the aggravated battery with a firearm came in 1989. If they wanted to eliminate, and they certainly had the power to, they could say, in cases of where there's a finding of both second-degree murder and aggravated battery with a firearm, there is no second-degree murder, and the accused or convicted must be sentenced on the aggravated battery with a firearm. Just to take a couple examples, if someone was shot in the baby finger by a firearm unjustly, and all the elements of aggravated battery with a firearm were there, that would be the crime of aggravated battery with a firearm. Again, if someone was shot in the baby toe by a firearm unjustly, and all the elements of aggravated battery with a firearm have been proven, those are aggravated battery with a firearm cases. The thing to evaluate, especially case-specific, is here. Is it more serious for Laquan McDonald to be shot by a firearm, or is it more serious for Laquan McDonald to be murdered by a firearm? Common sense comes to an easy answer on that in this specific case. Therefore, my findings are that I will sentence Mr. Van Dyke on the second-degree murder count. Again, applying Justice Thomas's reasoning, I find that the lesser offense in this particular case and set of facts is the aggravated battery with a firearm. Just as an aside, all those shots were done within a range of any place from 14 to so many seconds, but less than 30 seconds at the most. So I consider that one act. So they would all merge, but I'm not going to enter judgment on that, as Illinois requires that with one act, one sentence, one crime. So therefore, there'll be no judgment entered in on the aggravated battery with a firearm counts, and they will merge. I'll enter judgment on the second-degree murder count. Now, again, anytime it gets easy for a human being to sentence another human being, that human being, whether it's a judge or if it determined in a death penalty case, the jury, they should get out of the business, all right? So this is not pleasant and this is not easy, but this is some kind of a profession that I chose, and I'm not complaining about it. But I certainly have to take in consideration all the feelings that are involved here today and throughout the whole trial. And I want to compliment the lawyers here. I don't have the exact figures, but initially the amount of information that they had was 500,000 emails, maybe more than 100,000 pages of discovery. Laquan's DCF files were in the neighborhood of about 8,700. People that have been here, you wonderful people, during the trial, know the expert witnesses, the reports that have been filed, the motions that have been filed. So both sides have done such a tremendous amount of work, and they're very professional. I want to compliment them. Now, moving on, you've been here today and you've seen the impact that this sentence, this crime has had on Laquan McDonald and his family. You've seen the impact on the Van Dykes and their family and the children. That's the shame. The family are suffering a tremendous amount of pain during this, along with Laquan McDonald's family and loved ones. And I've sat here time and time again, and along with my brother judges that are here in this courtroom, and it's just so senseless that these acts occur, because you can see the pain on both sides of the family. And I think Mr. McMahon said it in closing arguments in the case in chief. This is a tragedy for both sides. So this is not easy, and I don't expect it to be easy. My findings are an appropriate sentence would be 81 months in the Illinois Department of Corrections, 2 years mandatory supervised release. Mr. Van Dyke, you have two rights I have to inform you of. One, the first right is you have a right to have me reconsider your sentence. That means within 30 days you'd have to file a written document called a motion to reconsider. In that written document, it must contain all the reasons why you want me to reconsider your sentence. If you could not afford an attorney for that motion and you wanted to have one in preparation of it, the state would pay for that attorney. Do you understand that right? You have to answer yes or no, or you don't know. Okay. The next right is you will have the right to appeal both the trial and the sentencing. And again, within 30 days, you'd have to file a different written document, and that document is called a notice of appeal. If you could not afford the appeal, the state would pay for your lawyer, would pay for your transcripts and all filing fees if you couldn't afford your appeal. Do you understand that right also?
Yes, sir.
All right, thank you. All right, there'll be a short recess. Well, that's the end of it. Court's in recess.